jobs are few, there's no employment, so employees just take whatever they're given because there's, hakuna kazi, so hao watachukua tu yenye iko.
So okay, the part for where to report any exploitation, I think the best is normally the labor office. What, like even in every, I can say in every county there's normally a labor office. So that's normally the first place to report. But there's someone also stated, and unfortunately most of these labor officers, because when you go to the labor office you find labor officers are normally corrupt. That's the unfortunate part. Because most of the time when you go and report, this labor officer has now to reach out to your employer. Most of the time the employer might bribe him. Then you find, because even most people who come now, by the time they come to a lawyer, they have been frustrated by the labor office. So I think also I feel like the labor office should be more vibrant in supporting the employee rights, because they're the ones even who are mostly on the ground. Because when you come before you file a case before court, it takes time. You need to get summons, you need to serve the other party, but not, for them it can be instant help. Because if someone walks into your office and you take action immediately, it's normally easier. So where you can report exploitation is normally in the labor office. But what I tell people, if you're not satisfied or you don't get help, there's normally now the courts. You can go to court. But now there's even someone who brought it up, like that relationship, you already have the employer-employee relationship. Yeah. So someone is scared to lose their job. But what I normally tell people, like, an employer is not supposed to terminate you for reporting them to, like, fighting for your rights. But of course a lot of people will be scared to sue their employer or report such even some even talking about the labor office, some even will be scared to go to a labor office to report their employer because they're scared of losing their jobs. But the laws are there to protect people. So I normally say, if you are under, because you know your rights, of course the worst that can happen is you'll be terminated. You lose your job. But and unfortunately, also the courts, they have said they can take 3 years. So it's not something that you'll go to maybe a lawyer's office and you're compensated immediately. So I think also I support the person who said that the implementation should be focused on, like even for courts. But now there's nothing much that can be done when it comes to court, because now when you file the case, you don't have control as the lawyer filing the case. But I think it's the labor offices whereby there should be vibrance there, because I think they're the ones who are on the ground who can ensure. And the moment labor officers take their job seriously, a lot of employers will not be free. They will not infringe on employee rights. It will be hard because they know the laws are working.
But where do you think the problem is exactly? If at all, Kenyans know they have their rights are protected at work, then could it be something to do with maybe money-wise, say financial challenges, such that maybe, for example, if I'm filing a case against my employer, then it will cost me a lot of money if you're going through that process for 3 years, for example. Is it anything to do with financial challenges? Yeah,
it can also be financial, because a lot of people will not afford, especially, remember the circumstances, it's chances that you have lost your job. So you don't have the finances to go to get a lawyer and the lawyer to, defend you in court. So most of the time it's normally also financial challenges for many people. So most people, they won't afford legal fees. Or even people have the assumption getting a lawyer is going to be an expensive affair, and someone just feels, let me move on with my life, let me just get another job and just move on with my life. But I feel if more people fight for their rights, that's the best way to actually just ensure everything works. Because employers will feel free if they know you feel like they can get away with it. But the moment a lot of people take it up to themselves to fight for their rights, someone said people know their rights. The moment you know your right, you can fight for your right. But many people are normally scared, of course, for losing their jobs and all that. But I feel the best way to fight it is people just standing up for their own rights.
If we normalize it, then at least it will be somehow better.
And it's so serious. Because if someone comes, they have the money to get a lawyer and everything, but they feel that the employer is so powerful, especially if they are for big companies. So they feel the employer is going to pay the judge. The employer is going to pay the judge. So they feel like it's not even about the finances, it's not about their rights. They just feel the employer is too powerful. Like, you can't fight them. But I normally tell people that when it comes to court, the laws are clear. The court follows the law. It's not about, because I normally tell people, even if worse comes to us, of course, no one wants to go through that vigorous process of court. Because, for instance, that's why there are appeals. So if you're in the lower court and you feel it was an unfair judgment, you go to the high court. If high court, you go to the court of appeal. Yeah.
So do you have pro bono cases with, matters of labor, work? Are there pro bonos?
Yeah, they're normally pro bonos. And I think even most lawyers take up employment matters more of pro bono basis. But of course, their compensation might come in at the 30% of the award from court. When the employee is awarded damages. Yeah.
Let's talk about the legitimate powers that an employer has over an employee. Because now, one of the comments say that employers feel like they have so much power over employees. Now the employees fear coming forward and, of course, reporting their employers or maybe suing them. So what powers do employers legitimately have over their employees?
I feel even the first one is resources. Even the moment you start that relationship, the employer is the one with the more power. Remember, everything comes from the employer, even the contract. When you go and sign the contract, someone is normally desperate for a job. Sometimes you find even as much as the contract, you may find someone even has, you have like 7 years experience. But now because you're desperate, you will get a job and you're paid 30,000, which of course is not like the amount of salary you're supposed to get based on your skills and your kind of education and everything. So I feel the employer will have more power because now you may find so that's why the employer will take advantage of that, because for you, you're coming in from a point of you really need that job. So the employer will draft the contract, and the moment you sign the contract, so there's no way the blame does not go to the employer. So I feel that's where, and remember that it's legal. Like as much as this person is being underpaid, it's still legal. Yeah.
At what point does managerial authority become abuse of power, Akili?
So I think managerial authority, mostly you find people with even when it comes to now, someone might just decide they don't like you in a company. And because they're in a position where they can terminate you, they actually terminate you, or they just frustrate you. So that's why even court nowadays, the law does not provide for constructive dismissal, but people normally sue for constructive dismissal. It's where the managerial, even we have had cases whereby the people in managerial position just frustrate someone because they just don't like you. Maybe you don't bend the laws here and there. You're too stringent, so they just want to get rid of you. So they take advantage of that power. So you find they just frustrate you, hoping you'll resign. So the moment and then if you don't resign, they just create something for you to just be terminated. So I feel that's serious abuse of power. So you find some serious people who are good at their job and everything, they lose their job just based on people who just feel they have that power. Yeah.
Talk to us about written contract. And I saw this comment somewhere that can you sue someone or maybe your employer if you've worked for them for some time without a written contract, or unafanya tu kazi but you have no written contract, can you sue them for that?
Yeah, you can sue your employer, but you have to have evidence of an employer-employee relationship. No matter if an employment court deals with employment matters. So there has to be an employer-employee relationship. But it can't only be proved through contract. So maybe if they were doing statutory deduction, like an NHIF, if they were being was being paid, that's another evidence you can show there was an employer-employee relationship. If there was salary payment, you're being paid salary there's no way you've been paid, maybe you've worked for 5 years and they're paying you salary. That's already evidence for a relationship. Yeah, so you can still sue your employer.
Even through M-Pesa? If you're being paid even through M-Pesa, that's still evidence enough?
So I hope it's from the company. It will make more sense if it's from the company. Yeah.
And not somebody maybe from Anne Odida to Ruth Tanui. That will not be evidence enough.
Yeah, but now, of course, it will also depend, because imagine if you have sent me for 5 years, but then now will shift to you to show that I'm not. But that's the first thing. I normally tell people that's the hardest thing. Sometimes someone walks into your office, but they cannot prove that relationship. They have nothing. This employer is not doing statutory deduction. This employer was paying salary in cash. So you have nothing to prove that relationship. So we normally say that it's a case that's already dead on arrival. Because of course the other person, the employer will lawyer up, will get a lawyer, and the lawyer will come and burden is on you, show the relationship. And I'm going to tell people, as much as you know deep in your heart it's the truth, you're working for this company. Yeah. This is a judge or a magistrate who doesn't know both of you. So the only way they know this person is saying the truth, or this person is saying the employer is saying the truth, or the employee is saying the truth, is evidence is brought. Yeah. So if you don't have any evidence to show the relationship, so it becomes hard, because you find most people they do this informal agreements. Yes. Yes, we call them the gentleman agreement, handshake agreements, whereby I'm working for you, but we don't have anything to show. You don't pay for me statutory deduction, you don't do pay. You pay me in cash, like you unanipea bahasha every end month. Then it will be hard for me to prove that I'm your employee. Yeah.
So is it mandatory for every employee in this country to have a written contract?
It's not mandatory, but the law provides for it. It's not mandatory, but under the law, like under the Employment Act, the employer is supposed to provide a contract between the parties. But there's no penalty for not providing for it. It becomes now consequential to a party now that, especially now for the employer, if there's no contract, like now that cannot be used against an employee, stating that because you don't have a written contract, it means there's no employer-employee relationship. Yeah.
Does this also apply to domestic workers, maybe back home, maybe my house manager, say my shamba boy, somebody who does 1, 2, 3, just small things for me at home? Should I be giving them a contract just in case maybe one day they want to take me to court and I need evidence? I know we talked about evidence. Sometimes if for that employer-employee relations, for my house manager, should they also have a written contract?
Yeah, it applies to them. So it's normally advisable to, so long as they're working more, they're not casual labor, like you not hired them casually for 3 months, which is normally from 0 to 3 months. It's normally advisable to have a contract in place. I normally say this, it protects both parties. And even as you as employing your house manager, it also protects you. Because now the contract is clear, you put the JD, job description, the hours, in case now if you want to part ways, it's clear on how that is done. So for instance, now you've said termination. In case of termination, you give each other 1 month contract. 1 month notice. So I think it's normal, it's advisable to have contracts. It protects both parties. Yeah.
Talk to us about contract out of a statute, right? Maybe sometimes the Employment Act states that the minimum days that somebody should get their leave maybe is 28 or 21. You tell us about that. But then, for example, where I work, they tell me that I'm only entitled to 15 days of leave. And maybe the entire period of a month, maybe just sick leave, or maybe just maybe 1 week or 3 days. I don't know what happens with that. So what supersedes the other? My employer or the Employment Act? If the Employment Act says that I am entitled to 21 days of leave or 28 days of leave, but my employer only gives me 15, what supersedes the other?
It's statute. The law supersedes the law stipulates that any policies or any procedures that the employer comes up with, it has to be in line with the Kenya labor laws, which includes the Employment Act. And the Employment Act gives a minimum of 21 days. It can go below 21 legally. If you want, you can put 26, 28, but the minimum, the law is clear, its minimum is 21 days. So in a situation where you're being given less than the minimum that the statute has provided, now this is when I normally tell, if you come now, let's say you're coming for a consultation, we give you options available for you. You can start by writing to your employer requesting that you be given, at least the minimum according to the law, or you can go to the labor office the way I stated, based on, depending, or you can even, you have a right under the law you can sue them because it's your right under the statute to be given a minimum of 21 days. But what normally happens most of the time is, this is normally something that a lot of employees will seek as compensation when they sue in case there's any termination when they part ways with the employer. So they seek for this. So if you find someone who was terminated, who started working maybe in 2012, but was terminated in 2026, will seek for, maybe they never took any leave days, they seek for it, and court will award it because the law is clear. So the court will not be like, the employer cannot defend themselves by saying, no, you didn't ask for it. It's clear in the law that you have to give minimum 21. Yeah.
So if, for example, I do not take my leave days this year, and I go to court and tell court that I did not take my leave days, so that will my employer pay me back for the days that I did not take as leave days?
No, that one now will depend. Like, if the employer has evidence to show you're the one who decided not to take your leave days, of course now that one you will not have any compensation. Because not what court compensates is when the employer is going against the law.
Okay.
They're the ones who are deciding not to give you those leave days. Yeah.
All
so that's what now will depend. Now go down to the evidence also. When do you have the evidence show that they didn't give it to you, and do they have the evidence that you're the one who didn't take it? Yeah.
There's something quite popular nowadays that we see a lot happening, in the employment sector, independent contracting, what others would call now consultancy. Where does that sit in the Employment Act? We see a lot of people going this route, they're employed, they're not employed, consultants are not employees. Then is it a safer way when looking for employment, the consultancy route?
I can say it's safer for the employer.
For the employer?
For the employer, because this person cannot sue you for any employer-employee relationship issue, like for unfair termination, because this one now it will be more of breach of contract. Yeah. So if there's an independent contract, remember, that's what I was telling you, when you go to court, the first thing you have to make sure that you have a relationship of employer-employee. Nowadays, even I normally see, even in the US, it's very common. Employers don't hire directly. You don't have any contact with the employer. They use HR companies. So you find for you, I've employed you, but you don't have any contract with me. Like maybe my company is called ABC company. You're working for ABC company. You don't have any contract with my company. I used a HR company to hire you. So for you have a contract with that HR company. Now see, for that one, it will be hard for you to sue me, to sue ABC company, our company, because you don't have any contract with us. So that's what most even I was saying in most countries, Canada, they normally do that to avoid these disputes. Yeah.
Is it safer for the employer or actually puts the employer at risk?
It depends, because I feel as an employer, you have much control if you have direct contract with your employees. But now remember, this time you don't have direct, and also you as an employee, you know you don't have any contract with this company. So you know you can do anything. You feel you're free. You don't have any direct contact with them. Yeah. So I just feel it has a certain risk for each party. Yeah. When you don't have any direct contract.
But no one can sue the other.
Yeah, because you don't have any relationship. Because you know, right now you're working for ABC company, but your contract is with a HR company. Maybe you'll sue that HR company, but you can't sue now the company you're working with, because you don't have any relationship. Yeah.
Walk us through the process of appraisals, and as we come to the tail end of this conversation, a friend of mine was talking about appraisal at their place of work, that she has only been there for about 6 months, yeah, but she has been appraised 3 times within that 6 months. What do you think might cause that exactly? Because now the concern was that only 6 months, her work is being assessed, how she's been doing at work, but there's nothing that is actually being done. Because my thinking is that for appraisal, there has to be something that leads to that, right?
Yeah.
If maybe there wants to be a salary increase, or they want to they want to give you another role, right? Then what do you think that would cause an appraisal 3 times within 6 months without anything? Like hakuna salary imeongezwa, hakuna cheo imeongezwa, but these appraisals keep coming up.
I think it will depend, because is this person still on probation?
Yes, they're on probation.
Yeah, because chances are, this is the time the company is trying to see if you are a perfect fit. So most of the time, they normally do them within this probationary period. Yeah, so that by the time they are maybe confirming your employment, they are sure about, the person they are taking, this person is a perfect fit for the company. Yeah, so I think that's, and also it will depend. Most of these companies, you'll find they'll have protected themselves in the policies. Now, see, for such a scenario, we'll have to look at also their policies to see if the policies provide for it. Yeah.
How about one who is not on probation, but they still, if at all, let's say this example that I've given you, what if they were not on probation?
So that one, now, that's how I normally say, I normally don't like giving general advice, but it will depend with the contract and the policies, what it stipulates. Because now because as long as it's not like, it's not like the normal PIP performance, where someone is trying to look at your performance, but nothing comes to, because it will. I think what I can just say, it will depend what is the appraisal for. If they have made it clear to you, this is the purpose for the appraisal, but if it's not leading to anything, it's something that you can raise. Yeah, especially if it's not affecting you performing your work. Yeah.
Okay, what is the minimum time period of probation? Because we're talking about 6 months probation. Is that really something that is legal, or doesn't the law recognize that? Because I know usually there's a 3 months probation, but 6 months?
It's 12, maximum is 12.
A year?
Yeah, a year. The law recognizes a year, but now the law is 6 months, then you can extend for another 6 months. But now it has to be with the consent of the employee, like you extend for another 6 months. Yeah, the law gives a maximum of 12 months for probation period. Yeah, the reason being, here both parties are trying to see if you are a perfect fit for the company. Even you, some people, even you, when you join a company, you want to know if you are a perfect fit for the company. Yeah, someone can say, 1 year is a lot of time for you to be on probation. But the law has provided for at least a maximum of 12 months. Yeah.
All right. So how would you advise an employee who wants to maybe file a case against the employer as we wind up, and this is your final question in a parting shot, for them to win that case? If, for example, I'm aggrieved and I want to file a case against my employer, what should I do?
So my advice would be get a consultation first from the lawyer. Go to a lawyer, let the lawyer understand the context of your case, then they can advise you, so that at least you know what you're looking forward to. Because sometimes employees, if you don't do that consultation stage, someone might, you see right now, it's through consultation that you'll know the matter might take 3 years. Because you know someone might come to sue assuming that within 6 months the case will be done. So I normally say get a lawyer to...
6 months? I thought a week we are done.
No, yeah, you see now, people might have assumptions. So I normally say the first place, get a lawyer to... Get a consultation from a lawyer, for a lawyer to advise you based on your case, so that you can even have an idea of, because I normally tell people not all cases it's guaranteed you will win. Some it's going to be 50-50 based on the circumstances. You see, like the one for absconding duty, the employer was justified. So maybe now you look at the procedure that was followed, so that at least you have an idea of what to expect. Yeah, and also I normally tell people, don't assume you will win the case. So even get to know what will be the financial repercussion if I'm to lose that case. Yeah. Though I normally tell people for employment cases, it's not like commercial cases. Even filing employment cases, it's like filing a claim. It's like almost, it's not more than, it's like based on anyway, it will depend with the attachments you're putting. Sometimes when it can go more than 2,000, but now I normally tell people for commercial cases, if you're suing for something that is subject matter is more than 1 million, you pay 75,000 for filing fees. But now for employment, it's subsidized. So even compensation, it's less compared to other cases. So sometimes I normally tell people, let that not deter you. I normally see some employees, when you tell them that bit, they're normally scared. They're like, but I tell someone, it's not normally for employment to prevent, the court is also supporting people to come and fight for their rights. So they can't put a lot of financial burden for you to scare you away from even coming to seek for your rights. Yeah.
All right, workers' right versus employer power. That is Wakili Ruth Tanui, an advocate of the High Court of Kenya, walking us through the thin line between legitimate employer control and violation of workers' rights. So there you have it. You're protected under the Employment Act of Kenya. And at least now you know if you want to sue, you have to consult your lawyer first. Thank you so much, Wakili, for making time for us to have this pertinent discussion. At least now we know some 1, 2, 3 about, our rights as employers, and of course employees also do have rights, but we'll be talking about employers some other time. Thank you so much for watching. That brings us to the end of this conversation.